Hi, it's John Terry. Thank you for joining me for this very special on-demand workshop. Joining me, and I will be introducing her shortly, is Ciara Lister, an attorney. And today we are going to spend some time talking about estate and medical preparedness planning. There's important things you need to know, and you need to know where you can go for help with your planning. And in the next 45 to 60 minutes, as we're spending time together in this on-demand event, we want to answer some commonly asked questions and share some educational information with you about estate planning. Now, although Ciara is an attorney and I am a certified estate counselor, there is not going to be any specific legal or tax advice given. I'm not a CPA, she's not either. What we want to do in our time together is to educate you on various retirement and estate planning topics that are commonly asked. The goal of our time together is to give you education and knowledge so that as you're meeting with your financial planner, with your estate planning team, you're going to be able to make a more informed decision about the type of planning that's right for you. Now, for me personally, there's a passionate reason that I share this message, and this is the people that you see on the screen here in front of you, my mom and dad. Growing up, my dad was a bivocational pastor, and from the time I was about 7 years of age, my sister was about 4, my parents began to pioneer a church in Oklahoma. We would drive an hour from Fort Smith, Arkansas, where we lived, every Sunday and every Wednesday night so my dad could pastor this small community church. Being prudent planners as they were, my mom and dad wanted to make sure that in the event something happened to them, my sister and I were going to be taken care of. So they met with a local attorney. They put together the estate planning documents that were necessary to provide for our comfort and our welfare. They named a guardian and found a family that would be willing to raise us in the event mom and dad were not there. Again, being prudent planners, mom and dad took out some life insurance so that if they weren't there, there would not only be people to take care of us, there would be the dollars in place to pay for that type of care that we may need as we grew up until we got to the age of adulthood. Now, fast forward many years, my sister and I are grown, married with kids of our own, and now my mom and dad have grandkids that they have an opportunity to enjoy. For the last 20 some odd years, I've been doing adult education in the area of financial education. And estate planning has been a very passionate topic of mine. And I recently found myself very near the hometown where my parents live. And after I did an event with some attorney friends that had asked me to come speak on this topic with them and to share my insights as an educator, I went to have dinner with mom and dad, have some of that amazing fried chicken that my mom loves to cook. So as we're eating dinner, I was telling mom and dad about the event, and dad smiled just broadly from across the table, and he says, "Well, son," he said, "I just want you to know your mom and I took care of that a long time ago when you and your sister were little." And I smiled and thanked dad. And as I was eating some cornbread and drinking some of mom's sweet tea, I looked back across the table and I said, "Dad, that's great." I said, "I am glad you did that planning when my sister and I were young." Now, let me ask you another question, Dad. I said, since my sister and I have grown up and we now have kids of our own and grandkids, have you done any updates to your estate plan to make sure that it currently addresses your wants and needs? And what I got from across the table was this deer in the headlights look that my dad realized that he had done planning well over 30, 40 years ago and hadn't touched those documents since. So we ended up going into the file cabinet and digging dad's documents out. And sure enough, the guardians that had been designated to take care of my sister and I, they've been dead for several years. The term life insurance policy that was going to provide the funding to take care of my sister and I in the event my parents weren't there was gone. The few assets that they had when they put this estate plan together were no longer in their possession. Nothing in their documentation matched their current lifestyle. There was nothing in their documentation that in the event they were unable to express their wishes with regard to medical care, nobody could express their wishes on their behalf. Nobody had been appointed for their financial care, could write checks and do things in the event they couldn't do that. So we had to have a serious conversation that night about updating their plan. And about 2/3 of the way through it, my dad looked across the table at me and he said, "Son," he says, "we're probably not the only ones that have made this mistake." He says, "Please do me a favor and don't keep our story a secret. Share the mistake that we made in not making sure we've done this and done it right. because I don't want other families to all of a sudden find out after mom and dad are gone that mom and dad didn't do what they should have done to provide for those they're leaving behind. So that's the reason I do what I do. And that's what we're going to spend some time talking about tonight. Now, this is me, grown up, and uh, again, I'm not the little boy anymore, but let me tell you a little bit about myself. Again, my name is John Terry. I'm a best-selling author and conference speaker. I've spent a number of years working as an estate planning consultant, working with a number of individuals, and I am a certified estate counselor. Received that designation through the Reed Security First Legal Association well over 15 years ago. Now, on the call with me and is also going to be sharing today is Ciara Lister. Ciara is a graduate of the University of Florida. She got her doctorate in law from the Ave Maria School of Law. She is the chief counsel for integrated trust systems, and she is also a network attorney working with clients that work through the integrated trust systems platform. Now, we're going to spend some time talking about a number of topics today. And again, we want to make sure that we're providing some education and information for you. If you haven't already done so, I would encourage you to grab a pen and a piece of paper and take a few notes as we go along, because we're going to share some information at a very high level to let you know what you need to know about estate planning, so that as you're having further conversations with the estate planning team or the individual that invited you to this event, you can ask more poignant and reflective questions that relate back to your reality and what's going on in your world. I want to take a few minutes initially and talk about the need for estate planning, and then Ciara will join me with some conversation in a few minutes as we get into the nuts and bolts of estate planning. But when we think about estate planning, there's really three important issues that we need to think about as we're planning for the ultimate demise. At some point, we're all going to leave this earth, and when we do, we need to understand that there's a cost to dying. There's funeral expenses, there may be probate and estate taxes that they need to be paid. That, of course, is obvious. You've got to pay when you die. Somebody's got to pay for the funeral. They've got to pay for the casket. They've got to pay for all the necessities that are there. There's another important issue when we think through estate planning, and that's how do we efficiently and effectively transfer our assets to the people that we want our stuff to go to when we're no longer there. If there are charities that we want to remember as a legacy, how do we effectively make sure that we've done that? And thirdly, and an area that's often missed in estate planning, is thinking into how we're going to provide for our surviving spouse, our children that may be minors and unable to manage their own affairs yet, or special needs children that may need care for the rest of their lives. Now, funerals in itself are quite expensive. And if we think about today, the average cost of a funeral in America is somewhere between $7,000 and $12,000. That's the funeral home, the burial in the cemetery, the headstone. And if unplanned for, it can be a pretty significant burden. Not everybody can write a $7,000 to $12,000 check out of their pocket. And if you haven't done proper planning and your assets have been frozen by the court, where's the money going to come from to pay for those funeral costs? Well, there's several ways, again, that you can pay for these costs. And as we already said, you can always write a check if the funds are available. But not everyone keeps $7,000 to $12,000 setting aside in a bank account to write a check to pay for a funeral that many people may not be anticipating that will happen for many years down the road. Some people will go to a funeral home in advance, the funeral home of their choice, and they will prepay a funeral plan, often called a prepaid plan, where today they purchase a funeral that may happen months or years or decades down the road to lock in the cost of a funeral today. But the vast majority of people use life insurance to pay for funeral costs. They can either do an assignment of part or all of the death benefit to pay those proceeds, or have the proceeds go to a named beneficiary who will then write the check to pay for those funeral costs. But failing to plan for the ultimate demise of our lives is something that's important, because when we die, there are a significant number of events that are going to require some type of cash payment. We've already talked about the funeral cost, but what about the medical cost that may have been incurred prior to? Maybe you got sick before you passed away. Maybe there was an injury or a prolonged illness that strung out for several years. Those medical expenses have to be paid in cash. We're going to talk about probate and estate planning and the cost associated to that. The year you die, whatever year that is, and however long from now it is, taxes are going to be due that year. Your income tax return will have to be filed. And if you have a large estate, there are estate or what we call death taxes that may have to also be paid in cash. So it's important as you think about estate planning to think into all of the elements that need to be addressed and have a conversation with the team that you're going to be working with to figure out how to mitigate those costs. Now, another area that's often overlooked is in the area of medical preparedness. And at the time we are recording this on-demand event, we here in the United States and around the world, we're still dealing with this coronavirus pandemic. And this pandemic has really brought to light and really manifested the lack of planning in this particular area. Many people don't have a living will, which provides guidance to doctors and medical staff about whether or not life-sustaining treatments should be administered or withheld in the event you can't make that declaration yourself. And the importance of having a power of attorney in place and appointing an individual or separate individuals to make healthcare decisions when you can't, to make personal care decisions when you can't, or to be able to manage your financial affairs in the event that you're incapacitated. Now, one of the most important reasons that we think about estate planning is caring for our heirs. Because at the end of the day, estate planning is not just about transferring our assets. It's about how those assets are going to be used to provide for the people that we leave behind. And an area, again, that needs to be addressed but often overlooked is in the area of income planning, or what we call survivor planning. Making sure that the money is going to be there when it is needed to take care of those you leave behind. Why? Because even though you may not be here, life is going to continue to go on for those that you leave behind. Now, life insurance, again, we talked about that in funeral preparation, but life insurance can also provide the liquidity, the cash dollars to not only pay for that funeral, but to create a nest egg, a financial windfall that your heirs can use to be able to create ongoing income. That could be set up so that they get a large pool of money. That money could go into an annuity or some other type of investment that would create a monthly check. Or there are life insurance policies available today that may pay some of the money in a lump sum, but then pay the rest of it out in monthly or annual installments over a period of time so that you have the ability to manage how your family members receive and have access to that money. You can also be able to get professional assistance as part of your planning if your family members may not be able to manage money as well as you do, or in certain scenarios, maybe you've got family members that have spending issues or gambling issues or other areas that they struggle in. And having someone manage the money on their behalf can be an opportunity to make sure that that money is going to be there for a long, long time when it's needed. Another area of planning that's very important is making sure that you're addressing who's going to take care of your children. If you have minor children and you're no longer there, or special needs children that may need care for the rest of their lives, who do you want to be able to raise them in the manner that you want them raised, to instill the values that you want instilled into your children, to give them the best opportunity for success if you're not going to be there to do so yourself? And not only appointing those individuals, but making sure that the funding is going to be there so that the people that may be raising your children or your special needs children, in the event that you are not going to be there, that money's going to be there to pay those ongoing expenses that they're going to need. Because life happens whether we are around or not. And as my parents discovered, estate planning is not a one-time event. It's a systematic process. We start estate planning when we get our first job and we start accumulating wealth. Because until you have an estate, there's no estate to manage or ultimately distribute. But all through our working careers, we accumulate stuff. And when we get to retirement age, then we get to manage that stuff and be able to use those assets for income and to enjoy life. But ultimately, we're going to distribute those assets and pass it on to the next generation. But life happens, and it's important that we update our estate plan because people get married. Unfortunately, people get divorced. We have children, we have grandchildren, we have great grandchildren. And as your life changes, And as the needs of your family scenario change, updating your estate plan to make sure that it is current and speaks to your wants and your needs and your wishes is so very important. Now, I want to shift over and have Ciara join the conversation with me because an area that is often not really understood by consumers today as they begin to deal with death, maybe for the first time, is in the area of probate. So, Ciara, let's talk about probate for a minute and maybe what the probate process is, but let's begin with talking about the last will and testament.
Yeah, hi, John. Thanks for introducing me and getting that overview for everyone. So, the last will and testament is going to be a document that everyone has heard about. Everyone might have some sort of version out there, but people don't really understand what the functionality of a will really is. At its basic, it's a legal document prepared under state law that names who receives your property. It must be probate and it is going to be public record. When you go to probate court, they're going to file all of your documents, all of your will into probate court, and it's going to be accessible by everyone. So, probate is the legal process following your death by which which your will is validated as authentic, assets are accounted for, debts are paid, the remainder of assets are transferred to your designated heirs. So essentially, you're going to probate court, they use your will as directions, and they're going to ledger up and account for everything you have and then divide it the way that they see fit with the assistance of your will. Titled assets must be signed to authorize transfer, and if you're dead, you can't sign your name to your deed, so there's going to be someone that's placed in charge of doing these things for you.
You know, that's an interesting observation that most people don't realize is that the deed to their house, the title to their car at death has to be transferred. But if they're dead, somebody's got to be appointed to sign their name. And that's one of the major reasons we have probate, correct?
Yes, sir. And it's something that could be easily avoidable by naming someone to do that for you. So, probate, like I said before, is a public process and your records are open for public inspection. This used to not be a huge deal before the internet, but now people can go online and pull all of your documents from the comfort of their own home. They don't even have to go down to the courthouse. It is a court administered process and typically requires legal representation. You have to file a court case just like any other case. So, most people are going to look to an attorney to help them to e file, to get those court costs filed and paid. Some states may offer a simplified probate process for small estates, but often you see an attorney enlisted to help in this process as well, because again, it's still complicated. You're still filing paperwork and it's still different state to state. And again, it can be a cumbersome process. This is going to take months to years and be dragged out like any sort of court proceeding.
And I know this public process and the fact that the records are open for inspection. I remember an event I did, Sierra, a few years ago, and I had an individual come up and was talking about the fact that when their dad died, there were what they called sharks. I love the analogy that they used, but they described the fact that there were some sharks that would float around the courthouse and would look for probate cases to be opened. And if they saw that there were substantial assets in the home, the families began to get calls for new siding for the house, for new windows, any way that anybody could figure out an opportunity to help separate the money from people while they were in distress came out of the woodwork to try to, again, relieve this family of hard-earned money to enrich themselves as a result of that process.
Yeah, we all know that when something's public record, you get a traffic ticket and then all of a sudden you get 500 pamphlets in the mail. This is going to happen to you when you have a public probate process. So the probate process, on average, takes 6 to 9 months, longer if contested. We all know the courts are a little bit different right now, so it might even be a more strenuous process going forward. But your assets are all going to be frozen while this happens. So the cost of probate is typically 3 to 7% of the gross value of your estate. Obviously, this depends on how large your estate is, but with your assets frozen, it's going to be a scramble for the person who is stepping up, hiring an attorney, trying to resolve your estate for your family. They are likely going to have to pay these kind of costs out of pocket and hopefully get reimbursed later. They're going to have to petition the court. So it's not a easy, oh, I'm getting money, let me use it for this probate process, because all of these assets are frozen and there's going to be very few exceptions, because the court is still trying to figure out who rightfully has the right to this money, so they're not giving it away to people who are contesting the will or paying someone to probate it.
Yeah, we experienced that with my uncle a few years ago when he passed away. He had never married, and when he died, he had named my dad in 7 handwritten wills as the executor of his estate. But every time he wrote a handwritten will, it was to his current girlfriend at the time. So it took us a period of time to figure out chronologically which girlfriend fell into what area of life before we finally found the right will that we could bring to court. And then after we got it there, my aunt, his sister, decided to contest the will. And as a result of that, there was no money to pay the attorney. And what few assets he had ended up being expended to defend against a sister that just decided that if she wasn't named in the will, nobody else was going to get any of the proceeds either. And it was a very cumbersome process. And I learned, and you may want to expound on this a little, Ciara, that anybody can contest a will for any reason.
Yes, everybody gets their day in court. Everybody gets to raise their concerns. The court doesn't know if your aunt was the proper person or your uncle's girlfriend. You have to imagine that they're coming from a place where they don't know your family, they don't know the situation, so they don't know if the last will is the last will. And if there's 7 of them, they're trying to figure out which one was written when and the timeline of things, and then divide the assets. So you have to see this from the point of the court has no idea what those people actually meant, especially if there's opposite wills or wills that contradict each other and there's contradicting interpretations of them. Your aunt might have read it one way and his girlfriend might have read it another.
Yeah, and think about how many famous celebrities have had the opportunity at death to all of a sudden people coming out of the woodwork to saying, hey, that was my dad or that was my mom, not even really having a legal claim, but just trying to have an opportunity to get in there for notoriety or whatever reason. So, again, it's an important area. And that's one of the reasons we use a will, Ciara, for peace of mind. Do you want to talk a little bit about some of the things a will can do for us?
Yes, so will is important because it is going to avoid intestacy. You're going to appoint guardians for minor children's. You're going to choose an executor. You can make specific bequests to individuals, manage assets, continue a business, and defer distributions to minors. So there is a lot of valid use for a will, and you're still going to have that ability to direct the court. It's just going to be a probated process, and a lot of things that you want to be public. You want the continuation of a business maybe to be public. You want the public to know who you want to be the guardian for your minor children. So it's not all negative that it's public. There's just some very negative things with public probate court.
Now, if they don't have a will, Ciara, I like to say no will, no problem, because the state has a will. If you die, what is called intestate without a will. But what's the problem with the state mandated version of a will, last will, and testament?
So the state has its own rules and regulations, and each state is a little bit different, and they're going to choose where your assets go at your death. Um, it's going to be strangers again making those decisions for you and following court cases that might not be applicable to your situation. So you're kind of just leaving it to a toss up. These are the rules. Someone's going to interpret them. They're going to take your assets and apply them to your family. So you're losing that control of where all the things that you spent your entire life collecting are going.
And the court, when they divvy those assets up, are going to follow a preset formula that are going to carve the assets out to the family members they designate as recipients. And that may be a completely different percentage than what you individually may have wanted.
Yes, I mean, absolutely. It's going to be a process that is not applicable to your situation. Obviously, you know your family the best and who needs your money and where you want it to go, and the court does not. It's just pre-designated X percentage for this family member, and it goes down the line.
So, Ciara, we've talked about probate and the problems with probate. We've talked about the fact that it's public record. We've talked about the fact that there is no privacy, that it can be expensive, that anybody can contest it. Your assets are frozen during this period of time. And if you don't have a plan, the state has one you may not like. So let's spend a minute talking about how we avoid probate. And I'd like to open with this statement. The goal of efficient wealth transfer or estate planning is to assure that your heirs get the portion of your estate as they intended. So, Ciara, there's a number of ways that we can avoid probate. Let's talk about those for just a minute, if you don't mind.
So, joint tenancy is a very common way to avoid probate. It's going to be joint names on the title, and the title passes to the surviving tenant at death. This happens, husband and wife own a house together, very common. Community properties with right of survivorship, again, that title passes to the survivor at death. You have taught and trust, where it passes savings account to heirs. Life insurance pays directly to heirs at the death of the insured, so it's a great way to account for those fees and a time when they might not have access to your assets. We're going to have lifetime gifts, and that's basically just transferring your assets before you pass away. Living trust, where assets are held in the trust for the benefit of the trustee during their life and for their heirs at their death, maintaining that control over your assets while you're alive, so you don't have to give them away while you're alive. And then the transfer on death, which is kind of similar to a taught and trust, or a pay on death at a bank, but it's going to permit your securities accounts and bank accounts and different accounts held by someone else to be passed to your heirs when you pass away.
So, a lot of these, when we think about these, we call these avoiding probate. But really, with some of those, Ciara, we're only delaying the inevitable. With life insurance, that's going to avoid probate because the money's going to go directly to the named beneficiary at death. If you have a lifetime gift and you give something to someone while you're alive, that avoids probate or at least pushes it down the road. But joint tenancy really only delays it. Right of survivorship only delays the inevitable if we haven't done proper planning. Would you agree with that?
Yes, with joint tenancy, obviously that surviving tenant is going to take over title, but then they're the only remaining tenant, and when they pass away, it's going to go to probate. So you have to continuously plan with these kinds of tools.
So, one of the areas you touched on is the living trust. And understanding that a living trust is a way that we can avoid probate, let's really get into the mechanics and understanding of what a trust is.
So trust is going to avoid probate, and it can avoid probate generationally. It's a fiduciary relationship in which one party gives another party the right to hold title to property or assets in a trust for the benefit of another person. With the revocable living trust, you have the ability to be all those parties. So you can give yourself the ability to hold your property for yourself. And then when you pass away, you're avoiding probate, and you can plan for estate tax mitigation, and you can actually enlist someone to be a professional manager of the assets if you require that, because you are appointing the successor beneficiaries and your successor trustee. So the people that are in charge of your assets and the people that are going to receive your assets are listed by you, and you can go generations into the future and really control all of your assets while you're alive because you still own them, and when you're gone because you are deciding where they go and laying out the rules.
So, Ciara, let's take an example here of John and Betty Smith and what that might look like in practical application. Can you kind of walk us through this chart, please?
Yeah, so in this example, we have John and Betty. So they've set up a co-grantor trust. They're holding these items together as the trustee. And you can see there John and Betty Smith as trustees. And then they are the beneficiaries, but at their death, they have successor beneficiaries, which looks like their two sons and their two daughters. In this example, you can see that all of John and Betty Smith's stuff, they have it as the creators, and they also have it as the trustees. It's being held in that trust. So they're all the parties. When they pass away, it goes directly to their kids the way that they want it to. Um, we don't know if that's even four ways or one kid gets more, but they can control that and make those decisions all the way up until they pass away.
So, one of the things I've always heard about a trust, and it's an example I've used quite often in a lot of the educational events I've done in a lot of community settings and college and university where I spoke, is thinking of a living trust as a treasure box. I used to use some pieces from a Monopoly game, and I would put the house in the box. I would put the car in the box. I would put money in the box, and I could take those things in and out. Can you elaborate on how we could think of a trust as a treasure box, Ciara?
I think it's a great metaphor. And if we can all just imagine you have that treasure box, that's your trust, and you're putting all of your items in it. But when you're the trustee and you're alive, you're the trustee with the key. And so you take the key and you can open it and take your items in and out, and you maintain control while you're alive. And then when you pass away, you lock that box up. The box goes to the successor trustee and they have the key. And on the key are the directions of everything that you want to happen with the trust and where you want it to go. So they open it up and then they distribute all those pieces the way that you wanted it to. Obviously, you have to trust that person with the key, but it's a lot better than having to trust a court with people that you don't know or someone that you're not necessarily paying to follow your rules that you establish.
That's a great analogy that you shared there, Ciara. So let's talk about the why of a living trust. Why would someone think about using a living trust as an estate planning document?
A revocable living trust is going to allow an individual to transfer title, property into a trust agreement and to appoint a trustee to manage these assets for the benefit of a designated person or persons. If the trust is revocable, the trust can be amended or dissolved, and assets can be removed or added during your lifetime. Again, that control while you're still alive is very important for many people. And if it's a living trust, the trust is formed while you are alive, which is important because you want to be able to put all the assets in there and decide what you're doing with your trust while you can make those decisions. If it's a testamentary trust, everything's getting put into the trust after the probate process. You're taking that empty trust treasure box to court with you and filling it later. You can try to direct what's going to go in there, but of course, if they're spending down the estate in probate court, you might come out with an empty box. So it's kind of important, very important, to put all of your assets into that treasure box before you get to the part where people are sticking their hands in there and picking things out.
Yeah, I think that's an important area that is often missed as well, Ciara, is the fact that people will create a trust, but they never put their assets in the box. And the downside of using the testamentary trust is that's typically done as part of a will. So you see an attorney oftentimes will do a will with a testamentary trust. They then get to take the assets to probate, collect the fee. They then get to collect the second fee to help set up the trust and put the assets into the trust after you're gone. Um, when there's a much easier and simpler way to do it, and as you said, if you can do it while you're still alive, you still have all the benefits of managing those assets and having the ability to dictate ahead of time what's going to happen to those assets when you're gone. Now, there are a few pros and cons. Let's talk about advantages and disadvantages for a minute.
Well, I think the first one avoids probate. We've gone over that one enough. There's going to be the ability to have a professional management of your trust if you want to have that. You can have the trust continuation by successor trustees. There's going to be no court intervention, and you're going to have that privacy where your estate is not public knowledge. The disadvantages are creditors may have additional time to file some claims against the estate. The asset transfer process can be a bit more time consuming than a classic probate example. And the cost to establish and fund a trust can be a little more expensive than creating a will. Historically, it was a lot more expensive. So I think that we've kind of solved that problem here, especially working together with the advisors and a team of attorneys. But I just like to think that we've found the answer there.
Sure. My grandfather was an attorney, and I remember growing up, one of the memories I have of the things that he would say was a will may be the least expensive estate planning document to implement, but when it actually comes to putting that into practice when you're gone, it becomes one of the most expensive ways to manage your estate when you're no longer there. And spending a little more money on the front end to do a trust cost a little more. But the privacy issues, as you pointed out, the ability to avoid probate, to make sure that you've picked the successor and that they know how you want your goods distributed when you're gone, there's huge value in that. Now, we talked about the box, the treasure box, and funding the trust. Let's just go back one more time, Ciara, and really talk about after we've created the trust, getting the stuff in the box, why that's important.
So funding, I think, is a little bit misleading term for people who might not have heard it. It is an archaic trust term where you hear trustee, beneficiary, settlers, all those kind of terms. Funding is the same kind of term where it essentially means ledgering or listing or assigning your assets to your trust. So when you create a trust, that's obviously the very first step. You have to create something to put something inside of it. And unless the trust is properly funded, the assets being transferred into the trust, the full benefit of the revocable living trust is not realized. So to avoid probate, you need to assign or fund your trust with all those assets that you want in there. So you're funding the trust with the assets, you're assigning, listing the assets. so that they're in the trust and they're there before you die so that your box is full and you pass on your box with all the assets inside of it.
So the last thing you want to have happen, Sierra, is to, at the end of the day, when I'm gone and I leave my box to my wife and my kids and my grandkids, and they open it up to see what I've left them, the last thing I want to do is to not have anything in the box. And I
Yeah,
think that's important.
unfunded trust.
Yep.
An empty trust would be even better, empty. So you don't want that. You want to fund your trust and put those assets inside your trust treasure box.
Now, Sierra, we've also got an issue that I've run into several times where we've had situations that I've done some seminars up in Kansas, Nebraska, a lot of areas where people are asset rich and cash poor. And as they're thinking into how they're going to leave their goods and their assets and all of the things they've accumulated, sometimes there comes an issue of how do I make sure we keep the family farm in the family? Or how do I make sure that I keep the ranch in my generational descent so that it continues on generation after generation after generation? We see that not only there in the Midwest where we've got a lot of farming and ranching, but out west in a lot of the vineyards that are there. Can we talk a little bit about how we name beneficiaries and why that's important?
Yes. So with naming your beneficiaries in a trust, you have total control. You can choose any of the designations, and common designations are spouse, children, other family members. You can choose an estate, another trust, a charity or corporation or partnership, any entity. It's important to keep these designations current because you might not want something to go to one of your children and go to the other. So you can really have that ability to customize and choose who your beneficiaries are and designate them, and avoid those designations being appointed by a court. You know, if you have an open um, designation in a will and it says to my family, that really can be interpreted very widely if you have a very large family. And some people include married in spouses and some people don't. So you have to be very careful, and you want to designate those people very specifically in your trust. Um, with those kind of things, you can choose distributions per capita, per stirpes, and of course, there's spousal rights. Per capita is going to literally mean per head. If the beneficiary predeceases the asset owner, the remaining heirs are going to receive an equal share. And then the per stirpes method, if a named beneficiary predeceases the asset owner, the beneficiary's heirs share in an equal portion. So per stirpes is a way that people often account for grandchildren that might not necessarily be born yet, or heirs that might not be born yet. And you can choose whether you're going to use per stirpes or per capita with your trust documents rather than being dictated by the state.
Yep. And if we go back to the example of John and Betty Smith, they had 4 children. And if we use the per capita designation and one of those children predeceased the parents, then the estate would be divided equally among the remaining 3. But if we were to use the per stirpes designation and that child that predeceased had a spouse and children, they would receive that one child's portion that had deceased. And that's the unique distinction between those two. And again, that goes back to a conversation that I've had multiple times with family farms, family ranches, vineyards, and things of that nature, where keeping things in the family line for whatever reason is important. And you touched on the fact that spousal rights and making sure that some states have specific requirements of what you have to leave a spouse. And that's part of why having a team is so important, Sierra. Would you not agree with that, rather than just trying to do it online yourself?
Yeah, absolutely. You're going to want to take into account what the spousal rights are in your state and then plan around that as well. And people hear the per capita and per stirpes, and it's not that one is better than the other. It's what's right for you and your estate plan. So you want to talk to someone and make sure that you don't just Google which is better and pick one. You want to make sure that it's doing what you want it to do.
Absolutely. And what about leaving the estate or naming the estate as a beneficiary? Is that a good thing, a bad thing? Is it one or the other, or maybe a possibility of both?
Again, it's going to be situational to you. These types of planning and decisions are so situational to the person who is creating the trust that it is so important that you know the decision on, you're making a decision based on both sides and weighing what can happen if you choose those options. So with an estate as a beneficiary, the assets are left to the estate, so it's going to be probated in order to be transferred to the heirs. The assets are subject to claims of creditors. Probate is a court administered process, again, that typically requires legal representation, and it can be cumbersome and expensive. It's not ideally going to be the right thing for most people to leave the estate as a beneficiary, but you can also imagine some situations where maybe someone doesn't necessarily have specific beneficiaries to leave, so the estate might be the right decision. You really need to work with your team and plan with your financial advisors, your attorney, CPAs, and know what is going to result in the outcome down the road, what you want to happen.
Sure. And another area, and that's why having this team approach is so important, because we recently had a case with a financial advisor that called me, and we were talking through a case he was working on with a family, and an asset that this family member owned was supposed to be designated so that it created a lifetime income for a surviving child that was quite young, and this was going to create an ongoing income stream for this child for the rest of her life. But because they named the estate as the beneficiary, in that particular state, the rules required that that asset not be paid out over that child's lifetime, but over a maximum 10-year period. And as a result of that, the intent of the parents to leave money for this child in a manner that would provide income for her for several years, well beyond the 10 years that were mandated by the state, it really messed up the planning that they had intended for that particular child. So making sure you get these designations correct is so very important. Now, what about minors as beneficiaries? What's the problem there, Sierra?
The issue is that you can't hand a lump sum of money or an entire estate to someone who is a minor. In most states, a child cannot legally enter even into contracts. And that's essentially what a trust is a contract to your beneficiaries. And in most states, they cannot inherit titled property. So what's going to happen is the court is going to appoint a guardian to oversee the assets until the minor reaches majority age. Court administered guardianship can be a very expensive process. And again, that's going to be someone that the court is choosing. So you want to make sure that you have guardianship appointments in there to control what happens to your children, not only on a personal level and who's assisting them in their personal life, who's going to take care of their money, and who can you trust to help take care of their assets. So you want to make sure that you have these things appointed on all levels so that someone's holding your assets for your children properly and for these minor beneficiaries, as well as if it's your child and they need a guardian, they're being taken care of on that moral, personal, ethical level that would coincide with your beliefs.
Absolutely. You know, one of the things I did in my planning as I've thought about minors as a beneficiary, I've got 6 children. And in thinking into my kids, some of my kids are okay with money and some of them aren't. Some of them can save money. Some of them, money just flows through their fingers like water. And thinking into these beneficiary concerns, one of the nice things about a trust is you can set up how the money is distributed so that not all the money is distributed at once. And maybe they get a third or a fourth of the assets at 18 and another third or a fourth at 23. And you can stagger how that money is paid out, because if you think back to Sierra, probably where you and I were back when we were 17, 18 years of age, and our philosophy of what money was for is a lot different now than we're older. So I think there's some unique advantages. Can you speak to that just a little bit? Did I lose you, Sierra?
Yes, my microphone just cut out and I'm so sorry I couldn't
That's
get it to
okay.
come
Now
back up.
you're back. Go ahead. Sure. Yeah.
Okay, where were we?
We were talking about that. I was saying that with my kids, I've got my estate planning document set up because they don't manage money. Some of them don't manage money that well. And so my documents are set up so that when my kids get to the age of 18, if my wife and I are no longer here, they get a small portion of the money that we have. And a few years later, they get a little bit more. And a few years later, they get a little bit more. But the ability of a trust to dictate and manage from a professional level how the money is distributed or conserved, even though you're no longer here, it is essentially allows you to control from the grave to a certain extent. Can you speak to that a little bit?
Yes. So with a trust, you can control from the grave pretty much in all aspects. You can make those decisions up to the day you die. So as your children age and obviously become more responsible or have different things happen to them in their life, they might become better with money or worse with money. So you can make those decisions until that time. And then you can have that control when you pass away and know that if they can manage their money, you can even divide it between children. If they can manage their money, one child can be given a lump sum when one other one could be underneath the guidance of a trustee for the rest of their life. It really gives you the ability to pick for every single beneficiary what you want to happen, who should be in control of the money, and how much should be given when.
So, do we refer to some of this planning as spendthrift provisions?
Yes. So, one of the major benefits of generational control is the spendthrift provisions or spendthrift protection. Money held outside of the beneficiary and held by the trustee is going to be protected from creditors, and it's going to be protected from the beneficiary themselves from improper spending or just going out and making those big purchases when they get a big lump sum of money.
And that's so important because if we think about how most of us have been trained to live life, we get a paycheck every week or every 2 weeks, and we're used to functioning in that cycle of a small amount of money hitting our bank account. And I know from a lot of the education I've done and families I've talked to over the years that when they've seen their kids get a lump sum of money, it's typically gone. We look at people that win the lottery, and all of a sudden, this money that should have lasted the rest of their lives, oftentimes in just a few years, is gone because when we see these lumps, large sums of money, and we're not accustomed to handling those, that can be problematic. So, as Ciara has shared, the ability to manage assets, even when you're no longer here, is one of the powerful features of trust planning itself. I want to take just a minute and talk about estate taxes that may be due at death. Because if you've got a large estate that you run into, you may come into a scenario where death taxes, as you may have heard them called, are due and payable. Because at death, if you have a specific size estate, and that's going to vary from year to year based upon the tax code, they're going to look at the total value of your assets. And if they exceed a certain threshold, then there is an estate tax that can be levied. You need to understand that according to the current tax code, those taxes are payable in cash, typically within 9 months of your death. Now, in addition to estate taxes that may be due, there's going to be administrative cost of having to do the calculations to determine what that is, filling out the appropriate forms for the federal level estate tax return. And if your state imposes an estate tax, those forms have to be filled out as well. And then after that, whatever is left over can be transferred to your heirs. Now, there are some provisions, and we're not going to take the time to get into those because it's a little more complex planning, but there are certain ways that you can account for a large estate, and at death, you can actually have an estate carve out where we create two buckets of money. And Ciara, can you maybe touch on that just a little bit, the AB trust concept of how we might can split some assets out? And then I want to talk about how, another way that we could pay for those estate taxes.
Yes, so the AB trust is just going to be one set of assets funding another trust. So that way you're not going through the entire probate process or any sort of transfer process when one spouse predeceases the other. It's usually a tool used for spouses.
Very good. Now, with the AB trust, again, it's a complex provision, a reason why you may need to meet with the team. But if you do have a scenario of estate taxes being due, and you don't want to take the money out of your estate because you want to leave that money to your kids, to your grandkids, to continue a business, whatever that might be, one of the solutions to pay for that, again, going back to a conversation we've had a couple of times, is life insurance. Life insurance is a very valuable tool in estate planning for a number of reasons. We've talked about it helping pay medical expenses, the final burial expenses, leaving money for a surviving spouse, kids, grandkids, leaving money to a charity. But life insurance can also be used to pay estate taxes. And oftentimes we will see a unique trust called an irrevocable life insurance trust used to own life insurance where you have a very large or very complex estate to create the dollars to pay those taxes at whatever point in time they're due. So again, an asset rich, cash poor Estate, like a family farm, a ranch, a vineyard, a large business concern, can be passed on and not have to liquidate assets to pay those taxes. And for about 1% of the cost of the estate each year, life insurance premiums can be paid so that those cash dollars are available, leaving money and leaving an estate intact for those that we leave behind. Now, Ciara, we talked a little bit, and I touched on it early on about medical preparedness planning. And this is a really big area of concern. And I've seen a number of articles in USA Today and AARP and several other magazines talking about this coronavirus pandemic, raising the awareness of the fact that many Americans haven't thought about these particular documents. Let's get in and first talk about a living will.
These documents, like the living will, are the most overlooked. People are ready to plan for when they die and where their assets go, but they're not ready to plan for a medical emergency or if the fact that they're incapacitated. The living will is a written statement of an individual's healthcare wishes in the event the individual is seriously ill and unable to give consent. So when you're incapacitated and can't make your own decisions, you need to spell out what you want for things such as pain medication, food or water, resuscitation, what coincides with your religious beliefs, and what you want as far as funeral or burial services before you get to that point when you can't make those decisions yourself, or maybe they're not going to trust you to make those decisions yourself. People just want to overlook this part of it because maybe it's not the most positive part of planning, as much as leaving your assets to someone, but you need to make sure that you are accounted for as well. Because when it comes down to making these decisions, it's going to be very tough on your family, and you don't want to leave this burden on your family, and you don't want to leave it up to some physician or stranger you don't necessarily know at all.
Yeah, this was really brought home to me when my grandmother several years ago came down with cancer. And when she was diagnosed as terminal, she spent the time to write out her living will and her statement of what she wanted with respect to care. And for the family, there was such an amazing amount of relief in the fact that we knew this is what Mama wanted. And we let Mama go in the way that Mama wanted to go. And knowing the composition of the family, some would have wanted her to hang on longer, some would have wanted her to hang on forever, some were willing to let her go. But having her make that statement up front was just such a relief for everybody in knowing this is what she wanted. Now, Ciara, we've also got the power of attorney for healthcare. Why is that important?
Yes. So then this is known as the healthcare proxy, and it's going to be an individual that you appoint to make healthcare decisions if you are unable to do so. So just like I kind of previously mentioned, you might not necessarily want the doctor making those decisions. They might know what's best medically for you, but they don't know what you want emotionally, religiously, or just because you've seen someone else go through another experience. So with the springing power of healthcare proxy, the power springs into effect when you become incapacitated. The doctor would have to deem you, or a medical professional would have to deem you incapacitated so that someone else could step up and help you make decisions. And you have appointed someone in your healthcare proxies in the paperwork that you would do with your living will and your durable power of attorney for healthcare proxy. And then they could step in when you become deemed incapacitated and help you make these decisions with your guidance and your directives of what you wanted medically. A HIPAA authorization can grant agent the access to principal's medical files and even things like mental files and your mental state. So they want to be able to see the entire picture of what is going on with you mentally, physically, and then your documents that put your personal opinion in there, and then they can make a decision.
Yeah, and that's a big deal because the HIPAA rules prohibit the medical profession from sharing a patient's information with a third party without that written consent. And if you've been named as the healthcare proxy, the attorney in fact for an individual, and you don't have that information, it's difficult to make a good decision. And that's a very important part of that durable power of attorney that you brought out. Now, the power of attorney, you can also do one, Ciara, for personal care and for financial care, but does that have to be the same person?
No, and most people do not have the same person. You have someone in your life who is very in tune with you emotionally and caring wise, and that's the person you want to put as your healthcare proxy. And then maybe you have a relative who is a financial advisor who is really great with their finances, and you want them to be your durable power of attorney over financial affairs. You can make the decision for it to be the same person or different people. again, have that control. You're not giving someone control over all aspects of your life. You're picking and choosing which aspects you want to go to which people.
Very good. Now, Sierra, we touched on special needs trust. This is an area of passion that my daughter works with special needs kids. And so I get a chance to talk with her and interact with some of the parents. And this is a big challenge. I know where I grew up, we had a special needs complex there in the city I grew up in that was a residence facility for adult children. It's kind of a weird word, but adults that had special needs, and they were going to require care for the rest of their lives. And this is an area, if not properly planned, can really create financial duress on an individual. So, can we get into talking a little bit more, maybe go a little deeper into special needs trust?
Yes. So special needs trust is going to be for any individual that you are essentially taking care of in any way. This trust is going to help preserve public assistance benefits for a person with a disability, which is the most important legal and financial reason that you set up a special needs trust. Medicaid qualification sets limits on the amount of assets a recipient can own or use without being disqualified from benefits. So the laws in this area are very complex and vary from state to state. So you're going to want to talk to knowledgeable counsel and advisors and other resources to make sure that you are not going to disqualify someone from their state or federal benefits because you accidentally left them too much money. You might think it's the greatest thing in the world to leave your special needs child all your money, and now they don't have these benefits that they were functioning off of and that were helping them work and live in society.
So, when we think about special needs trust and we talk about these government benefits, they provide like basic needs. But I know in talking with some of the residents that were there at that facility that I still from time to time visit because I have some friends that I've met and learned, some of them I went to school with, that because of the progression of their disability, they're now residents in this home. But they tell me oftentimes that the government benefits don't provide everything, and that's where proper planning comes into play.
Yeah, the government benefits are really only going to provide basic needs such as food and clothing and shelter, and mental benefits, but they're not going to provide things that necessarily are up to a standard of living that you think that people should be at because they are trying to provide the basics for everyone to survive. So with a special needs trust, they're going to be able to provide supplemental needs such as utilities, medical care, special treatment, education, job training, or even just entertainment. You're going to allow the government to provide those benefits that are very basic, and then you can hold outside this money that's just allocated for these extra. They may not seem extra to you, but these extra expenses, such as the supplemental needs or extra medical care, because not all medical care is deemed necessary. The one must decide whether or not to disinherit a child with disabilities or use a special needs trust. So you hear often that someone will think that because their kid is being taken care of by the government, or their dependents being taken care of by the government, that they'll just disinherit them and give the money to their other relatives and hopefully they'll take care of them or whatever it is that they think. And this is not the best way to plan for something like this because you want that money to be set aside for that person to be able to be used for situations that they need it. You don't want to just give it away to other people who might lose it or improperly manage it or not even take care of the person that you want it to go to. So with this trust, you can nominate or choose the person that is going to make sure that the person that is depending on government benefits also has other things that make their life enjoyable and better.
So I think you can see up to this point, as Sierra and I've had conversation, that this is an important area of planning, and there's a lot of moving parts to this. One of the reasons the individual that invited you to attend this on-demand event and have an opportunity to hear this is because this individual is concerned about your welfare and your well-being. And one of the areas that they want to do is to provide education for you so that as you're thinking into how you consider what an estate plan looks like for you and your family, you've got a general understanding of the basics that are there. Now, I want to, as we get ready to wrap up, I want to touch on one other area that has been commonly used in estate planning to provide that income gap for a spouse, children, and grandchildren, and how some of the rules have changed. And just want to make sure that you are aware of that in your planning. And again, a reason to go back to the professional that invited you to hear this event so that you can have a discussion, put together the appropriate team, and we'll talk on that in just a second as well, to make sure that you are putting together a plan that works for you. A stretch IRA is really a concept that is listed in the IRS tax rules in terms of how we manage traditional IRA money, 401k money, simple IRA, SEP IRAs, or other programs that are out there. And all of us know that one of the major benefits of using a traditional qualified retirement plan is the money that we payroll deduct or we write a check and put it into these type of accounts. We don't pay any taxes on that money until we take it out. So tax deferral allows the money that we would have paid in taxes to continue to earn and grow interest, so we can make money faster over time because there's more money in the account to grow. Now, once we get to a certain age, used to be age 70 and a half, due to some tax law changes, it's now age 72, all of a sudden you get a notice that you can't defer taxes forever in an IRA or in a 401k. At some point, Uncle Sam holds his hand out and says, you've got to start paying some taxes on this money. And you get a notification from the custodian of your IRA or 401k that you now have to start taking required minimum distributions. You'll hear that referred to as an RMD. I remember when my dad got his first letter from John Hancock, he called up and says, I don't need this money yet, but they're telling me I got to start taking money out. What's going on? And so I had to explain to Dad that tax deferral is only allowed to go on for so long. And then at some point, you've got to start taking at least a minimum amount of money out every year. Now, the stretch IRA concept was a wealth transfer strategy that allowed us to extend the deferral period on a traditional IRA or other types of retirement plans. If you didn't need the extra money now, like my mom and dad, they had saved well and they've got money that they're living off of, and they got some other accounts that they're just taking the required minimums, but they're allowing that money to grow so that as they get older, they've got additional dollars that they can tap into because the cost of goods and services get more expensive the longer we live. As we get older, our bodies begin to wear down and we tend to spend a little more money on health care. So those additional dollars can be used for a variety of different services. But another neat thing that we can do with these type of accounts is leave the remainders of that money to a surviving spouse, to a child, or a grandchild. That was one of the unique features of a stretch IRA. And essentially how it worked was this way. You as the IRA owner would name your spouse or a child or a grandchild as the beneficiary of the IRA. If you didn't need to pull a lot of money out, you would just take the minimums out each and every year. And then when you die, whatever money is left over, that individual that had been named as the beneficiary, rather than taking the money in a lump sum and paying taxes on all of that at once, they could begin to take required minimum distributions based upon their own life expectancy. So think about that. You're 75 and you've got to take out a certain percentage every year. You leave it to a grandchild that's 20. Well, their life expectancy is probably 65 or 70 years. So their RMD amount would be very, very small. So you can see how a stretch IRA was a very beneficial tool to be able to provide income for you if you needed it, but more realistically, to provide lifetime income to a named beneficiary when you're gone. And because they only had to take smaller distributions over their lifetime, they were paying less money in taxes year after year, and the money that remained in the account continued to grow on a tax-deferred basis. Now, there are some disadvantages to using a stretch IRA, and if you leave money to a surviving spouse or a child or a grandchild and they die and they don't live to normal life expectancy, then all of the benefits of the stretch IRA features may not be realized by them. Of course, Congress could step in and change the tax laws at any time, and they recently did that, and I'll explain what they've done and how that's impacted the stretch IRA. But another area is in the area of poor investment returns. Think about the people who in 2001 and 2008 were planning to retire. They had money in an IRA or in a 401k or a 403b or other retirement plan in the stock market, and the stock market took a major downturn, and people lost 30, 40, 50% of their money. Again, if this is your scenario and that's where your money is and it's lost, then you may not be able to leave the amount of money that you want. And if the losses are great enough, there might not be any money left to leave to your kids or your grandkids. And it's important to remember that even if you're setting up a stretch IRA, as long as you're alive, you still have to take your required minimum distributions. And if you fail to do that, there's a pretty significant tax penalty that's involved. But there was a major change that recently took place with the passing of the Secure Act. Now, the Secure Act changed how we can distribute money from an inherited account. Now, if we're leaving money to a surviving spouse, which is a common use of this stretch IRA tactic, then those distributions can still be made over the spouse's lifetime. So using a stretch IRA strategy can be a great way to leave money for a surviving spouse to make sure that they've got income above and beyond what's there. You've got to remember that when you die, your surviving spouse loses one of two Social Security checks if you're in retirement, or even if you haven't made it there yet, they're only going to get one Social Security check and not two. If you're receiving money from a pension or another qualified plan that doesn't have survivor benefits and you die, those benefits are not available to your spouse. So this income planning is important, and this is where a stretch IRA provision in an IRA or 401k or other account can be important. But if you're leaving money to a child or a grandchild, somebody that is a non-spouse, they no longer can take distributions over their lifetime. Now, under the new rules, children, grandchildren, or other non-spouse beneficiaries can only receive monies for no more than a 10-year period. Now, there's no formula in terms of how they have to take the money out on a year-to-year basis, but the entire account must be distributed over no more than 10 years if it's a non-spouse beneficiary, with a few exceptions. If you have a minor child that you've named as a beneficiary, they can continue to take those required minimum distributions until they get to majority age, and then the 10-year rule on the balance applies. Now, if you've got special needs children, chronically ill children, they can continue to operate under the required minimum distribution rules just as they previously existed. Or if the non-spouse beneficiary is no more than 10 years younger than you, they can still use the same provisions as existed before. Again, another reason to meet with a financial professional as part of a team. But where we often see this non-spouse 10 years younger, maybe you've named a sister like myself. My sister's 3 years younger than me. So if I named her as the beneficiary of one of my IRAs, I passed away, she could still take the money over her lifetime using the RMD strategies because she's only 3 years younger than me. And as long as they're within 10 years, we're good. Now, one of the ways that we see stretch IRAs often used to make sure that we can use these guaranteed lifetime options is to use an annuity. A fixed annuity operates very much like a CD issued from a bank. It's going to give a fixed rate of return. Money's going to go on a tax-deferred basis. An index annuity gives you the opportunity to have market-linked returns so that you get a portion of the upside, but unlike a direct exposure to the market, if the market goes down, you don't lose any money, you just don't get any gains in your account that year. An annuity is one of only a handful of instruments that can guarantee a lifetime income stream that you'll never outlive. That's a positive reason to consider annuities. Another positive reason to consider an annuity for a stretch IRA or part of your planning process is many annuities today have some unique hybrid features or enhanced riders that in the event you get sick and require care at home or in a nursing home or assisted living facility, there are enhanced riders that will pay additional dollar benefits to you to help pay for that care. There are other types of enhanced riders that at death, it will pay an additional death benefit enhancement, again, providing additional dollars to your heirs. So it may be something that you want to consider. But in addition to annuities, there's a number of different places that you can use a stretch IRA. You can use mutual funds. You can use a stock brokerage account. You could work with a managed money professional with an investment account. You could go to a bank and work with a CD or a money market account. But it's important to remember that no matter what type of financial instrument you use, every financial instrument, be it an annuity or any of those listed here, has their own risks and their own potential returns. That's why it's important to have a team around you. Now, as we wrap up, there's some points to ponder and some things you need to consider. These are questions that you need to answer. And if you can't answer them yourself, it's a reason to get back with the professional that invited you to hear this event, to have an opportunity to have a discussion with them, to talk to the members of their estate planning team, the attorneys and the CPAs, the financial professionals that they work with, to be able to help you find the right solution for you and your family. So here's some important questions and things to consider. Number one, do you have a will? A significant number of Americans don't. Matter of fact, one of the last reports that I saw that was done in a study of American households said that less than 15% of all Americans had a formal written estate plan. So the will is really the starting point of that. And if you have a will, is it current? Or have you done like my parents and put an estate plan together and you haven't touched it in 30 or 40 years? As Ciara shared, do you have written advanced medical directives, that living will, those powers of attorney, and those other documents that in the event you can't express your wishes, have you documented those so the people around you that love you and care about you know what you want done when you can't voice that yourself? Do you have a living trust? Does it make sense for you to implement a trust into your estate plan? Now, if you do, again, is it current? Have you made sure that it's up to date with the way you're living life now? Has it been properly funded? Have you assigned and listed all of those assets that are a part of that trust so that you're putting your goods in the treasure box, as Ciara talked about earlier? We talked for just a minute about estate tax planning. Does it make sense to use an irrevocable life insurance trust or some trust-owned life insurance to pay for taxes that may be due? Important questions you need to answer. Have you thought about how your surviving spouse, your children, or your grandchildren may be financially impacted when you're no longer here? Have you done an analysis of the types of monies you're receiving today and what happens to those dollars when you're no longer around? Which leads me to the question, do you have a survivorship income plan put into place? Have you thought about specific bequests that you want to leave? Are there specific things that you want to leave to a child, to a grandchild, to a charity, to a friend or a neighbor? Are there things that you want to leave with them to be remembered by, but you haven't documented that yet? And especially when you're leaving something to kids or grandkids, do they understand the significance of these planned gifts? You know, I think back to some of the things that my grandparents left me. My grandfather was a doctor, but he was also a lawyer. And he left some of his legal things to me. He left some of his medical things to my sister. And understanding what the significance of those gifts were and how he went to school to learn one profession and then went back to school to learn a second profession, and valuing the effort that he put forth had made those gifts very important to me. Now, have you thought about using a stretch IRA strategy? And if you have, has the change in the rules, because the tax laws have changed, impacted the way you're planning to provide for your spouse or your kids or your grandkids when you're gone? Do you need to revisit that? Now, here's a powerful statement that I want to leave with you as we think about things to consider. Have you thought about the financial statement that you're going to leave to the next generation and how you're preparing your heirs right now to continue your legacy for the generations to follow? You know, if we think about how long it took you to accumulate the wealth that you have, the blood, the sweat, and the tears that were required, have you taken the time to pour that knowledge and that wisdom and that insight into your children and into your grandchildren and instilled in them that same worth ethic, that passion for seeing to it that you're not only leaving something for your children, but for your children's children and for the generations that are come after you? Now, what are your next steps? We've talked about a number of things at a very high level today. Ciara and I have shared a number of topics with you, and now at this point you're going, well, that's a lot of information, and I don't really know what to do with it. Well, let me give you a suggested next step. What I would like to do is I'd like to encourage you to schedule a complimentary appointment with the professional that invited you to attend this on-demand workshop. I'm sure as a result of hearing what we've shared today, you've got some questions. So I would encourage you to get with them so that they can help assemble a team around you to get the answers to your questions. I think it's important that you sit down with them and review what your planning options are, and whether you've got a plan in place that just needs to be reviewed or you don't have a plan at all. I think it's important that you schedule that appointment and have that conversation as soon as possible while this is fresh on your mind. You know, the last thing I want to see you do is to do what a lady that was one of my Sunday school teachers growing up. She had an opportunity to hear me speak at their church about estate planning from a biblical perspective. And at the end of it, she came up and she patted me on the head as she always did when I was little and thanked me for what she called my talk. And she said, John, the good Lord's taken care of me my whole life, and he's going to continue to take care of me for the rest of my life. And I looked at this wonderful lady that had poured into me for years, and I said, ma'am, I appreciate what you've said, but let me also say that God's not going to do for you what you need to do for yourself. And you need to make sure that you have a plan in place. Well, fast forward just a few years later, she'd never put anything in place, and she got sick, and she needed care, and there was no plan in place. They were asset rich and cash poor, and they began to have to sell off the family farm 1 acre at a time to pay for care. And by the time this lovely lady was gone, over half of the family farm that had been in the family for generations was gone, never to be recovered again. And as it looking back, when I saw her later on in life before she passed away and she looked at me, she said 2 words I'll never forget. If only. If only I had listened. If only I had acted when you encouraged me to act, this wouldn't have happened to my family. So I think it's important that you meet with the individual that invited you to this event. They have attorneys that they work with. The individual that invited you here is connected to the Integrated Trust Systems National Network of Estate Planning Attorneys. Ciara and her team are available to help you put together a plan and the documents that are unique for you. That individual has access to an accountant that, in the event it's needed, can help you with the taxation issues that may be important to you and your business. They're either an insurance agent or they're an investment professional of some type who can help you put together the plan that you need. And whatever areas that they're lacking in planning, they have relationships with other advisors that they can bring to the table to help solve your problems and put together the plan that's right for you. They essentially want to bring it together. They've got a team that they've put together to really do one thing, to help you solve your estate planning problems and to give you some financial peace of mind. One of the neat things I like about the ITS arrangement is they can meet with you even if you're not able to get out of your home yet, using an online, highly secure portal where you can engage with estate planning attorneys, you can engage with the accountants, and engage with the financial professionals to get the type of planning that you're done. And once it's completed, you'll not only have those documents in hand, but you'll be able to access those digitally 24 hours a day, 7 days a week, 365 days a year through that very same secure online portal. And you can log in there to make revisions and changes to your plan at any time. New grandchild, new great-grandchild, child gets married, child gets divorced, you get married, you get divorced. You can make those beneficiary changes and updates at any time as long as you're alive. And best of all, this entire process is affordable. So what are they bringing together? A national network of estate planning attorneys, the opportunity to bring your tax professional in or to work with one of theirs that they have available to them, and of course the opportunity to work with a knowledgeable financial professional. But at the end of the day, this entire group of people is working for you. Their goal at the end of the day is to understand your wants and your wishes and help you put together a plan to preserve your legacy. The planning you do today is the greatest I love you gift that you can leave for your family. So as we get ready to wrap up today, I'm going to ask Ciara in just a second if she's got any parting words, but I want to say from me, thank you for attending. Thank you for investing in yourself to learn things that maybe you didn't know or to be reminded of things that you knew and hadn't thought about. The financial professional who invited you to hear this event is going to be following up to see if you would like to have an opportunity to talk about what you've heard today, and I would encourage you to do so. So, Ciara, as we wrap up, are there any parting words that you'd like to leave with the folks that are listening to this on-demand event today?
I hope that they watch the whole thing and that they move forward with at least doing some sort of estate planning. I know that we've made it very easy for them to have an entire team, so I hope that they reach out to the proper person and we get to work with them. But I at least hope that this made them think that they need to do some planning for their family's future and for their loved ones.
Absolutely. And whether you work with us or somebody else, I think Ciara said it best. It is important that you get this planning in place. So, again, the financial professional who invited you to this event is going to be in touch soon. And on behalf of myself, John Terry, and Ciara Lister, we want to thank you for joining us, and we hope you have a great day.